Senator Kennedy, I went a little over, and you're welcome to do the same if you wish.
Thank you, my friend. Congratulations to all of you. I hope to be able to ask each of you some questions, but I do want to stay within my time limit. Let's start with Ms. Clark. You've been nominated by President Biden, served on the federal district court, which means, of course, that the Court of Appeal is going to review all of your decisions. What is the appellate standard of review for question of fact?
Thank you for the question, Senator. I have not worked on an appeal in my 14 years of experience. I believe that it is reviewed based on abuse of discretion would be this.
No, it's clear error.
Clear error.
As the federal district court judge, you're going to have a lot of discretion on determining facts. How about if somebody appeals one of your decision and they say you made a mistake on the law? What's the appellate standard of review?
Thank you for the question, Senator. Again,
You're welcome.
I mentioned, I have not worked on appeals. If a question like that came before me, I would thoroughly research the law. I understand that there's de novo review, abuse of discretion, and clear error are the different standards.
Okay, but you don't know today the answer.
Thank you for the question, Senator. It would be
welcome.
something that I would need to research further.
Okay. How about a mixed question of fact and law? What's the standard of review on that?
Thank you for the question, Senator. Again, my understanding are that the different levels of review are de novo, abuse of discretion, and clear error.
Well, but that's a question of law and fact is different.
Thank you for the question, Senator.
You're
Again, in my 14 years of experience, that is not an issue that has confronted me.
Okay. All right. Well, you've been nominated for the Southern District, I think. Is that right?
That is correct.
So you'll see a lot of securities cases?
Yes.
Okay. Tell me what SEC Rule 10b-5 is.
That's a rule that deals with fraud. I have not litigated a securities matter. If I were to confront one, I would thoroughly research Second Circuit and Supreme Court precedent, and I would apply the law to the facts.
Ms. Clark, you've been nominated to the
Senate confirmation hearings are meant to vet our future judges on their experience, knowledge, and ability to serve. But what happens when a nominee struggles to answer some of the most basic legal questions? Today, we're breaking down a remarkable exchange between Senator John Kennedy and federal judicial nominee Sarah Clark, nominated by President Biden for the Southern District of New York. This is one of the most high-profile and legally complex jurisdictions in the country, and Senator Kennedy wasn't pulling any punches. Senator Kennedy opens courteously, inviting Ms. Clark to go over time if needed, but the politeness quickly fades as he begins his questioning on fundamental legal standards. The moment starts innocently enough, but Kennedy is clearly testing whether this nominee understands the appellate standards that she would be subject to as a district court judge. He asks, "What is the standard of review for a question of fact?" Ms. Clark replies, "Abuse of discretion." Kennedy corrects her, "No, it's clear error." This is Law School 101. Knowing the difference between clear error, de novo, and abuse of discretion is foundational for any federal judge. But what's more concerning, she admits she's never worked on an appeal in 14 years of practice. Things only get worse. Senator Kennedy moves on to mixed questions of law and fact, asking for the appropriate standard of review. Clark again deflects, citing a general need for more research.
To the Southern District of New York. It's where most of our securities cases are litigated. And SEC Rule 10b-5 is about as basic as you can get. You want to take another crack at that and tell me what Rule 10b-5 does?
Thank you again for the question, Senator. I regularly confront new issues of law in my practice, and when I do, I thoroughly research the issue.
I know you're going to thoroughly research it, but are you telling me today you don't know what Rule 10b-5 is?
I only have that basic understanding.
Okay. All right.
The stakes are too high, especially in courts that shape major financial and constitutional outcomes. What did you think of Senator Kennedy's questioning? Did the nominee meet the moment, or fall short of the bench's expectations? Let us know in the comments. And if you want more unfiltered coverage from Washington, make sure to like, subscribe, and turn on notifications. This is one hearing we'll be hearing about for a long time.